June 9, 2025, at 6:30 PM. Do I have a second?
Second.
Aye?
Aye.
Aye.
Thank you. I'd like to everybody to stand for the Pledge of Allegiance. Pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I just got one announcement. This upcoming Wednesday, June 11th, we have a playground meeting in front of the select board. That'll be at 6 PM. So I'm hoping that a lot of people show up for it. Let me see, is there any public comments? Can you grab that? Thanks. I have 3 people here that would like to speak. I will start with Mary Ann Gagney, a Wild Circle.
Hi. I have a brain injury, and so sometimes my speech is affected. If you can just give me some grace with
You can
time.
take your time. It's all right.
Okay. I'm here tonight not because I want to be, but because I feel that I need to be. Last week, I sent an email to the select board with a concern over why our fire chief remained at town meeting while a house fire occurred in our town. As a proud daughter of a former fire chief, I know that a fire of this nature takes priority over town meeting, and that the chief should have responded immediately. That did not happen. The Situate fire chief, however, and a Situate engine were dispatched to the scene immediately to work alongside the Marshfield firefighters. And the towns of Duxbury and Pembroke both sent manpower and apparatus for station coverage. Yet our chief was a no-show to his own fire for a good hour and a half or more. I simply wanted to know why, as this is not the first time that this scenario has played out. So I respectfully sent an email to the board. Historically, Mr. Darcy has replied to my concerns on issues from his personal email with accusations, condescension, name-calling, ridicule, and political tirades. His response to this email was no different. He accused me of not having trust in the Marshfield firefighters. Nothing could be further from the truth. I am a fierce supporter of our firefighters, and I pray for their safety when they answer calls such as the one referenced above. Mr. Darcy went on to accuse me of being disingenuous and having, and I quote, someone else compose my email. I can assure you that my thoughts and my words are my own. He questioned where I was getting my information from without taking into consideration that I am very knowledgeable because of my background about fire operations. Instead, he chose to attack my character and my integrity. He also falsely accused me of politicizing a tragic fire for a Marshfield family. This is a baseless accusation that I take great offense to. I grew up in a public service family. I am a nurse. My heartfelt thoughts are with this family as they recover from this horrible ordeal. As I have told Mr. Darcy before, There is absolutely no room for politics in the fire service. In closing, Mr. Darcy, there was no need for you to send this accusatory email to me, but you did it anyway. As I said, you have done this several times before. There is a pattern here, and it feels like harassment. In the future, I will contact Mr. Kelly and Mrs. Simpson only. Your harassment of me ends now. On another note, Mr. Moran, I want to personally thank you for taking leadership and helping our town through this difficult time. Thank you.
Thank you, Ms. Gagnon. Craig Hannafin, Union Street.
You can cross me off. I'm here for something else.
Mr. Duffy, Bryant's Lane.
Hi, good evening. My name is Neil Duffy from 17 Bryant's Lane, Brent Rock. I'm a direct abutter of the Jetty restaurant, and I realize there's going to be discussion later on, but I once again want to state how difficult it is for,
Excuse me, this is on the agenda. I don't know that this is appropriate for.
I signed up,
Public
so
discussion, so.
it's a public discussion.
It's on
It's
the
just 2
agenda.
minutes.
I'm a direct abutter, and I guess you can see what kind of neighbor I have. It's been incredibly disruptive to my neighborhood, this outside dining, outside, really a concert venue, 0 feet from the property line of a residential neighborhood. I implore this select board to reinstate the 35-foot screening and buffer bylaw that it's been on the books for quite a while. Just think of how every other neighborhood near a restaurant would react to the buffer zone being reduced to 0 feet and a outdoor concert venue being popped up, say, next to the Bridgeway, or popped up next to the Mamma Mia's or the Fairview. And think of how those neighbors would react. My neighborhood's the same. We lived in a very peaceful neighborhood before COVID, and it's been really incredibly disruptive since then. And another issue I pointed out a few weeks ago, because there's 14 fewer parking spots in the Esplanade, we have people parking on sidewalks that are blocking pedestrian walkway, and people are walking on the streets because there is no parking in Brant Rock. And lastly, there's an issue with notification. My neighbors, the abutters of this restaurant have not been notified of any of the expansions that have been going on. There's a whole patio behind the restaurant, and we weren't notified of it. We weren't notified when they removed the handicap parking spot. We were notified of nothing that this restaurant ever does, are the abutters ever notified. And I'd like this discussion to start. I think it's best for the neighborhood if we reinstate the 35-foot buffer zone and we increase the parking in Brant Rock. Thank you.
Thank you, Mr. Duffy. All right, Andrew says he's not in a rush to get out of here. I imagine he probably wants to be part of the discussion for the Jetty as well anyway, so I was gonna do the stretch code first, but I will bring up the Jetty for the first discussion. So, this was taken up last year, and I was an opposing vote to it, and I had questions, and a lot of the questions are popping up right now in regards to the issue here. So, I guess the one thing I want to start out with here is Mr. Galvin. In the zoning, the way I'm reading the law, does the zoning fall into the select board in regards to this, or do we establish that we are gonna be the zoning authority under this?
You're not the zoning authority. It was a provision, amendment made to state law, chapter 48, section 3B, that gave you the authority, notwithstanding the provisions of the zoning act and our zoning bylaws, to allow outdoor table service. And your predecessor board authorized outdoor table service at the Jetty. But that doesn't make you the zoning authority, it makes you the authority over whether outdoor table service may be permitted. When the law changed, I created a potential guideline and sent it to the board. I believe the board adopted a guideline, and then at a regular meeting, because that's all it was required to be, discussed whether outdoor table service was gonna be allowed in the parking lot of the Jetty, and I believe the board authorized that. I don't know what plan was authorized, or if there was a plan that was authorized, but that's my understanding. The zoning board of appeals retains all of its authority to approve site plan changes, and there's a current change in front of the board right now by the Jetty having to do with some landscaping and we'll call it like bollards and things like that in the parking area. I don't think that there's any changes being proposed to the outdoor table service. They're proposing, I think, one handicap parking spot on the site. It's coming up tomorrow night at the zoning board of appeals. This issue came up before.
I don't see this on their agenda for tomorrow night,
It's on the agenda. It's a continued public hearing.
unless it was shortened up, but I didn't see it when I was looking at it earlier.
The memo that I sent out to everybody yesterday, I think I copied you all, has it on there as a continued public hearing. I think they had asked for a plan or some further details on a plan from the zoning board of appeals for tomorrow.
Yeah, and I was just looking at the calendar, unless something was missing, I didn't even see the Jetty on it.
It was on their agenda because that's how I prepare my memos, so.
All right, it's, well, I'm saying, when I looked at the calendar, it didn't look like it was on there for the meeting tomorrow night.
It wouldn't be under the new public hearings, it would be on a continued public hearing, which is the second part of their agenda.
No, all right. Because the reason I asked for about the zoning is, letter B in this, notwithstanding the provisions of this chapter, any special permit, variance, or other approval issued thereunder, or any general or special law to the contrary, a city or town may approve a request for expansion of outdoor table service, including in the description of the licensed premises as described in subsection C, or an extension of an earlier granted approval. Before such approval, the mayor, board of selectmen, select board, or other chief executive officers, as established by charter or special act, shall establish the process for approving such requests. So, when I read in that, it's either established by charter or special act, is it, the charter has already established the zoning part of it in regards to it?
No, the reference there is to our existing zoning bylaw, or general bylaws, or our town charter, and it says that the select board have the authority, notwithstanding any charter provision, general bylaw provision, or zoning bylaw provision, to authorize outdoor table service without going through all of the requirements that one would ordinarily have to go through in order to get site plan approval to have outdoor service. It was a matter that came up during COVID. It was a requirement, or a lot of businesses were able to thrive and have outdoor areas, and the legislature saw fit to give local boards of selectmen or mayors or chief executives the authority to expedite the process of approving outdoor table service, and that was the genesis of that change. You don't have to have a public hearing, you just have to do it in a meeting after you adopt a guideline. So the select board asked me to create a guideline, I did that. I believe that the board discussed outdoor table service at the Jetty and approved something, I just don't know because I wasn't here, of what was specifically approved.
So, Mr. Chair, just for the record, the Select Board meeting of June 10th, 2024 indicates the application for outdoor table service and the vote that was taken at that time. It's in the Selectmen's materials this evening.
No, I've seen that earlier. All right, so, I mean, the issue here is whether, so there's nothing in this, because if I remember correctly last year, in regards to the paperwork received, there was some stipulations in there that if this was approved, there were certain issues that could not be undone. So, can the select board at any point rescind this if they didn't want to grant the seating anymore?
I don't remember what the guidelines said, because I don't have it in front of me. It would be whatever you adopted, but in general, with respect to site plan approval, the zoning board of appeals reserves the right on its own motion or on the motion of the property owner to modify its site plan approvals. And if you reserve that right, you also have that right. You also have additional authority, in my view, as the licensing authority for the liquor license to deal with this issue, if you think that there's a problem. So that's what I would tell you.
All right, so I guess the follow-on question is that us or a future select board, if they chose to, they could undo this if we so choose to approve it tonight.
I mean,
or in the future meeting.
I don't know what the vote was that night. I don't remember what the exact guidelines say, but generally speaking, our boards reserve the right to modify any site plan approvals that are given. And that's been my experience for the last 32 years.
If I may.
You could, right there.
So, thank you, Board. My name is Attorney Sean Cullen. I represent the Jetty. I would just like to briefly draw the Board's attention to Provision 3 of the Board's decision of June 10th, 2024. Paragraph 3 specifically says, "This approval may be suspended or revoked by the Select Board for any violation applicable state and local laws, bylaws, rules, and regulations, or said approval is no longer permitted by state or local law." My reading of that provision is, I think Chairman Kelly pointed out at the last meeting, or the May 19th meeting, that this approval can only be revoked or rescinded by the board if there is a substantiated violation of either the conditions that are set forth in this approval, there are 9 of them on the last page, or if the bylaws, there's a violation of the bylaws, there's a violation of the ordinance, or the state or local laws have been changed. None of those have occurred, so respectfully, I don't think the board can revoke or rescind that decision. That was properly granted back in June 10th, 2024, and unless any of the conditions that are specifically set forth in that approval have been met, there's no basis for the board to revoke or rescind that.
Yeah, that was, I remember that was one of my concerns, I remember that being in there, and this is what I was kind of concerned on, so, I mean, with that being said, and I believe, what was your name?
My name is Attorney Sean Cullen, C-U-L-L-E-N.
Sean Collins?
C-U-L-L-E-N, Cullen.
Oh, Cullen. Attorney Collins, I believe he's correct. Is there a way you can verify that right now, Bob? Because that was my whole concern the whole time in regards to what was received, and I believe what the board last year approved on.
I have a copy of the document here. I'm happy to pass it up.
Bob wants to take it.
I'd like to see it because I haven't had possession of that document, but if you believe that there's a nuisance going on as a result of this, then I may disagree.
Well, I mean, that's, I believe that's the issue at hand here, especially with Mr. Duffy. He's saying there is, but I know, getting reports from our building commissioner, he felt that there were no issues to be had, I think now and in the past, in regards to the matter. And so, I mean, that's another issue at hand in regards to it. So I would rather wait and see what town council says in regards to what was agreed on by the board last year, and see if it concurs with Attorney Cullen in regards to the ability to rescind this if it is possible or not, especially under the how it was written last year and approved by the board.
I would agree with the chairman, though, that I think the issue is the difference between a substantiated cited violation as opposed to unsubstantiated anecdotal evidence, which somebody comes forward. That is not going to be sufficient under any measure. You're going to need to have some sort of citation, some formal notice that the town has issued that there's actually been a violation On top of that, I would think that you would also have to give my client an opportunity to cure that before you would go ahead and revoke or rescind that approval. Neither one of those have occurred. There's never been any citation, there's never been any substantiated violation of any noise ordinance, any light ordinance. The town commissioner, the building commissioner, went on site during the evening to verify whether the lights were problematic. He took pictures, he measured it, reported back to the town. There was no evidence of any violation, that the jetty has been fully compliant. I would just further note that there is a long, long history of this. While the outdoor use started in 2020 during COVID-19, the actual application, when this was first applied for outdoor approval, when it did require ZBA approval, was back in 2018. That approval was granted in 2019. Mr. Duffy filed a formal appeal of that action. One of the bases of that appeal was the allegation that he did not receive proper notice. An allegation that he again repeated today. I heard that same allegation on May 19th. That allegation is demonstrably false. There is an order. There is an order.
Point of order.
Hold on. Yes.
Point of order, I don't know if this is the right. forum.
Respectfully, Mr. Chair, he doesn't have the
Lobby,
authority to
without
raise
any
the
of us
point.
having a chance to say something.
I'd like to speak, I'd like to say something.
I'd like to finish what I was saying.
No, go ahead.
There was an order of the Plymouth Superior Court in 2024. I have a copy of it here today. I'm happy to pass it up. When Judge Brian Glennie of the Plymouth Superior Court expressly found that the town of Marshfield gave proper notice to Mr. Duffy. Mr. Duffy was a part of that appeal. Mr. Duffy received that judgment. Mr. Duffy is fully aware
May I
of that
speak?
decision.
Hold on, let him.
Yet Mr. Duffy has repeatedly made that representation. Mr. Duffy also stated on May 19th, and again today, that he did not receive proper notice of the June 10th, 2024 hearing when the approval was originally granted, the modified approval which no longer required the ZBA approval. That again is demonstrably false. The type of notice that Mr. Duffy was entitled to in August 2024 is not at all the type of notice that is required under Section 11 of Chapter 40A. The notice required of the August 10th, 2024 hearing was simply the notice that the town publishes on its website. I have a copy of that. The town fully noticed that. Item number 7 on that agenda was the approval and the request for the jetty to seek the outdoor dining. Mr. Duffy's allegations that they did not receive proper notice has both been rejected by a court of law. It is
My
also,
neighbors and I signed a petition saying.
Did you finish?
he was not noticed.
no.
No, hold on, Mr. Duffy. You get, hold on, let him finish.
For time clock?
I didn't put one on it. Go ahead.
So again, he's repeatedly made allegations that he didn't receive notice. Those have been not only rebutted, they've been found contrary by a court of law, yet Mr. Duffy does not accept those and continues to repeat those. Between 2022 and 2023, Mr. Duffy made seven requests for code enforcement violations to the town. The town found that there were no violations at any point in time between 2022 and 2023. This respectfully is a pattern of harassment and abuse by Mr. Duffy because he does not like the fact that this is a commercial area where there are numerous commercial buildings and entities. Brant Walk, as this board knows, revitalized this area, passed an amendment to the district overlay in 2014, which allowed, part of the purpose of it was to revitalize this area, to bring back some economic growth. Mr. Duffy purchased his property in 2016 through a commercial entity, even though it isn't a
And I
residential.
think you're getting beyond it right now. So, I mean, the whole thing is that we're just focusing on the outdoor seating. My opinion is I don't think we need the history of why Mr. Vaughn purchased the property and all that. I know I've seen in here, I believe what you brought up in regards to proper notice. I'm just trying to think, I believe, yeah, I think right here, upon approval of an amended license, the local license authority shall provide notice of amended license to the commission. Actually, no, that's not it. I believe there was supposed to be a notice sent out to the abutters. So am I not correct about that?
There may have been some additional advertising, but the town also placed the notice. So, and this is the notice that the town placed on its website advertising. There was some additional advertising that was done, and that was done, but again, the town placed notice, and this was on the agenda.
Yeah, but what about a direct notice to the abutters, though?
We didn't get anything in the mail.
Hold on, Mr. Duffy.
That was done, Your Honor. The fact that he's claiming he didn't get it in the mail was not the point.
Is there any way to prove it?
It's beside the point at this point in time. I mean, that's really, but again, I mean, his allegations that he didn't receive notice of the ZBA hearing has been found not credible by a court of law. I would respectfully say that this is, again, the same allegation, the same type of thing that he's repeatedly said. He said that there's been numerous issues with violations of the ordinances. There's no evidence of that. There's never been a citation of it. These are just...
I know, yeah, I understand that. I explained that earlier in regards to citations. I mean,
They're
Andrew,
just the repeated-
seen Andrew's comments in regards to his written letters in regards to that he found no issues with it and everything. That Andrew put letters out and verified that, you know. So, I mean, it's, I think everything you said, I think I have an understanding of, and I think that my two board members as well. So let me just get Mr. Duffy's thoughts. What would you like to say?
Thank you, Neil Duffy, 17 So, back in 2019, when the Jetty proposed an outdoor patio behind the restaurant, now, I'm saying behind the restaurant, not beside the restaurant, we didn't get any notice. When they removed the handicap parking and put a patio there, we were not notified. And we were not notified in 2019 either, and I have at least, I don't know the list with me, but I have about a dozen neighbors who signed a letter saying that they too were not notified that the Jetty was going to put a patio behind their restaurant, within 0 feet of a residential neighborhood. Now, there is a buffer and screening zone of 35 feet, and that's on the books. That is a town bylaw, and has been a town bylaw for every business, restaurant, establishment, as it pertains to a residential neighborhood. Now, this restaurant, because of COVID, was allowed to bring their restaurant and the outdoor seating right up to 0 feet from a residential neighborhood. And again, our neighbors are great. We wanted the Jetty to survive, so we allowed it. We didn't complain. It was COVID. We wanted everyone to do well. And since then, it's been 5 years of continued noise and disruption to our neighborhood. And yes, I put in a number of requests for compliance, and I unfortunately, I guess there is no sound meter or decibel level meter that the town owns to actually take a measurement, because it's been brutally loud. Can I speak for the other neighborhoods in this town? Does this now set a precedent that now every restaurant can now build an outdoor concert venue right up to the property line? Is that what this is all about? Is that what this town is going to allow? Are we going to turn ourselves into Where's Beach? This is the town of Marshfield. The 35-foot buffer zone is there to protect the neighbors, is there to protect the residents of the town. And I believe that Attorney Galvin said that ultimately the select board has the say as to whether they're going to allow this to happen. The select board has the final say in town. It's not a fancy lawyer in a fancy suit can talk all night about whatever notifications he wants to. It's the town select board that has the final say in this matter. I implore you to protect the residents of this town, because you know, if it happens here at the Jetty, it's going to happen in every other business. Why should every other business abide by the 35-foot buffer zone if this one doesn't? The argument's very easy. If the Jetty can violate the 35-foot buffer zone, well, why can't every other restaurant?
Right.
Why can't every other bar?
Right.
Well, you let him talk for 20 minutes, let me talk.
Well, I get it, but the whole thing is that you kind of repeating yourself, so you could...
Well, all right. My point is, think about what this has done to Brent Rock. You, Mr. Darcy, you were one of the guys who voted last year for it. Have you seen what Brent Rocks look like? Everyone's parking on the sidewalks. Have you seen that?
I've seen a lot of abandoned and blighted businesses in Brant Rock, and we have one that's actually surviving and doing well and thriving after it was a death trap for many, many years.
A death trap, sir?
Yeah. Have you seen how many restaurants have been in that spot over the years and not survived and not made it? And I've seen around Brant Rock all the blighted and abandoned properties. Yeah.
Well, yeah, we got a whole...
Well, hold on, Mr. Duffy. You keep complaining about not getting to speak, and yet you keep interrupting others, okay? What I have seen over the last several years, is that you throw everything at the wall to see what sticks. And in my mind, that really impacts the credibility.
I want you to
The
explain yourself,
building
sir.
commissioner has
Explain
been on
yourself.
site multiple times.
Explain yourself, Darcy.
What's the issue?
Well, you're just being rude to a resident, all right? I would like to say something, Mr. Chair, if at all possible.
That's up to Mr. Duffy.
I rest. My point is, you're setting a precedent that every other business, every other restaurant, every other bar can now say, well, if you allow the Jetty to go right up to the property line, well, why can't I? You've set a precedent. And now it's going to happen in every business, every restaurant, every bar, every automobile dealership, everywhere. That 35-foot buffer zone now doesn't exist. But this select board has the power to right this wrong.
All right,
It's the select board's,
Duffy,
it's the select board's,
You've heard it.
thank you so much.
I would just,
Hold on.
Okay, so I would just like to say that they were awarded the fact of an outdoor deck in the back, and they were supposed to make an amendment to the fence with sounding, and it was supposed to be increased height, and that had not happened. I do have some concerns that now that we have this ability to have people over there, they've been able to extend their occupancy, which I don't believe is fair for other residents. Basically, you can double your occupancy by having your parking lot now turned into the restaurant. So I do have a concern there. I also don't understand how a restaurant can stop having parking spots and then have this influx of people that are now outside and that they're adding to the Brant Rock parking. Mr. Duffy is not the only person I've heard complaints. I did speak to the abutters you gave to me, but I do know some of the restaurants have questioned why a restaurant can just decide to have outdoor dining. Can the Venus do this now? Can the Old Haddads, just open up and have eating on the parking lot, so adding to their occupancy. So that concerns me. But what I'd like to do is I would like to find some common ground. I'm not looking to take it away. I understand the previous board gave you outside dining, but I'd like to find a compromise because Mr. Duffy didn't buy his house next to an outdoor dining area, and there is no buffer. I've been back there. There is no buffer. And if we could find a compromise and maybe half that and bring some parking spots back, I just think it might be the way to go if both sides are willing to agree to it. That's my thought.
Thank you, Trish. Steve, are you all done?
Yeah, I mean, if I'm asked a question, I try to answer it,
I get you. It's, everybody has their own way of answering things, so.
I just.
Go ahead, because I got something to add here.
I'd just like to make 3 quick points. With regard to the noise, I'd like to note that the Jetty voluntarily closes down its live outdoor music at 8 p.m., even though this board approved it to 10 p.m. So they're voluntarily shutting it down 2 hours before they're required to in order to try to be a better neighbor. The other thing about the parking, I think it's incredibly important to note, because this would be an issue if this was still under the ZBA, that there is a type that not everyone can complain about a loss of parking. Mr. Duffy is able to park at his property. He doesn't rely on on-street parking. Look, but that is, in order for Mr. Duffy.
I'm referring to the pedestrians of Brant Rock and the handicap.
Mr. Duffy.
Hey, I'd like to speak too.
Hold on, Mr. Duffy,
Look, sorry,
he's speaking, please.
I'll give you a minute.
Give him-
You're not going to give me anything. I'm entitled to speak, sir.
So am I.
So, respectfully, in order to have standing to raise that, he has to show that he has lost a parking space. The fact that there's other people who are coming in and trying to use the business that may find it more difficult to park, if it doesn't directly affect him, he does not have standing to raise that as a complaint.
Well, I mean, the whole thing, hold on, Mr. Duffy, the whole thing is that his parking situation doesn't matter, this is my opinion. I think it's a question of the use of the parking lot that is impacting his quality of life.
But it's not impacting his quality of life because.
Well, I mean, let's put it this way, Mr. Duffy, stop, please. You're not living there, he is, and all that, so that's something, that you could make a comment on at the moment.
My point is
So-
probably more technical, and that at least under the heightened level, if this was still a zoning appeal issue, if this was a zoning issue, in order to actually raise parking as a challenge under the zoning code, he would have to show that he's directly affected in a particularized way that's different than the general members of the community, i.e. that he requires on-street parking, and that the removal of the Jetty's parking spaces, which then reduces the on-street parking that he would otherwise require, that would be a particularized harm that would then affect him. If he is able to park on his property, he does not suffer any of the particularized harm that he would be required under the zoning code. He just has the generalized harm, which
All right,
is what
Elizabeth,
the chair.
I want to get back to the notification. So right here, the local board is now solely responsible for approving amendments to changes in outdoor table service only alteration of premises. Amendments related to indoor alterations necessitate complete alteration of the premises application process with the ABCC, mandating ABCC approval in adherence to the provisions outlined in the Liquor Control Act, Mass General Laws, Chapter 138, including, but not limited to, advertisement, abutters notification requirements, and the local board hearing. So there is a notification, an abutters notification requirement in this, and as far as what Mr. Duffy is saying, is that he has not received one. I don't know if there's any other abutters here that live in the same vicinity that abuts the property, if they could verify if they have or have not received one. But as of the moment, unless my look at it is that there could be proof shown that the abutters, prior to last year's approval of the select board in regards to this, and them getting notification, I think we'd have a problem here.
So, well, respectfully, I think there's a distinction between notice that's given and notice that's received. All that is required is that notice is sent. The lack of receipt is irrelevant. The town's records would verify that proper notice was in fact given. Mr. Duffy can claim all day that he didn't receive it, but if proper notice was given, his lack of receipt is irrelevant. It's essentially the same issue that came up with the Plymouth Superior Court. If notice is given, you can't ignore it and then claim, I didn't get it, so therefore it's not proper. All that's required is the notice to be sent.
I don't believe Mr. Duffy ever said that he received notice and chose to ignore it. He
No,
says
but-
he's
no,
never,
but-
he's never received it.
No, I understand.
And all the, Elizabeth, I mean, I have Mr. Duffy there, there's an abutter, and I imagine there's probably 2, maybe 3 or 4 others that probably abut the property.
But the town's records would verify that notice was properly sent. If he didn't receive it, that's irrelevant. If it's sent, it's sent.
Okay, hold on, all right, so, Attorney Galvin, do we have a way of verifying that notice was sent out to the abutters prior to the select board last year taking this up in regards to this change, this alteration of use of the parking lot?
The statute in 2024 doesn't require notice. In 2019, when the original site plan was amended,
That's what I was saying.
not only was there notice to abutters required by mail, but there was published, advertised, public hearing 2 consecutive weeks, 14 days before the hearing.
Well, I mean, here's what Jenna sent me, and this is Wednesday, May 1st, 2024, at 4:30 PM. On April 30th, 2024, Governor Mario Haley signed into law an act making appropriations for the fiscal year 2024 to provide for supplementing certain existing appropriations and for certain other activities and projects. The text of the law can be found here. Obviously, it's a click where you can, on the email. This email will provide updates related to the process changes resulting from this new legislation. Now, this is where I read last time. The local board is now solely responsible for approving amendments to changes in outdoor table service, only alteration of premises. Amendments related to indoor alterations necessitate complete alteration of the premises application process with the ABCC, mandating ABCC approval in adherence to the provisions outlined in the Liquor Control Act of Mass General Laws, Chapter 138, including, but not limited to, advertisement, abutters notification requirements, and the local board hearing. So the only thing is that, as of last year, it appears on April 3rd, 2024, this was signed into law, and I believe we didn't take this up until May, June, maybe, somewhere around there, I think, of last year. Go ahead, Town Administrator Moran.
Thank you. Just, Mr. Chair, I want to note that sentence that you're reading.
Yep.
the important clause in that is amendments related to indoor alterations. Okay? What we're dealing with is outdoor.
Correct.
What we're dealing with is an expansion of capacity relating to use of a parking lot. And I think that the question isn't about notice, it's about what Select Board Member Simpson is bringing up. Does the board want to revisit this and see if they can come to common ground to alleviate Mr. Duffy's concerns and allow the Vaughns to continue to operate a business?
I mean, I see your point there, Town Administrator Moran, but it says the local board is now solely responsible for approving amendments to changes in outdoor table service only alteration of premises.
Right.
So the whole thing is, then it goes, amendments related to indoor alterations necessitate complete alteration of the premises application of the ABCC.
Right.
Mandating ABCC approval and adherence to the provisions outlined in the Liquor Control Act, Mass General Laws 138, including but not limited to advertisement of buzz notification. So the whole thing is that, I think, between that first sentence and what you're saying, I think it's kind of meshed in there.
It's not a well-written paragraph.
Right, so the whole,
Mr. Chair, but
Yeah.
I believe that the notice requirements really pertain to the indoor alterations under the way this is written. So, again, I think the more fruitful path for the board to explore is whether or not a compromise can be reached.
I mean, I'm not opposed to some kind of compromise. I mean, I do, as I'm reading this, I do see a point that the local board is now solely responsible for approving amendments to changes in outdoor table service, only alteration of premises. Amendments related to, I have the feeling, to be honest with you, Town Administrator Moran, that there was a mistake in regards to not writing, I bet you're supposed to be outdoor, not indoor.
Well, I think that they,
Because why would they put this in regards to it, in regards to outdoor activities?
because they're giving broader discretion to the local board for outdoor changes in table service, while they're requiring similar notice requirements for indoor alterations as to, which was the status quo. So they're distinguishing where the board has more of a role than they previously did. I agree that it's not well-written, but I don't think it's a mistake.
Mr. Chair, could I?
Yeah, go ahead,
Sure.
Steve, absolutely.
No, you're totally fine. So I would just make maybe one suggestion and then one comment, which is that we do have a zoning enforcement officer in the audience for the town tonight who could probably answer some of our questions and would be a local expert that we could lean on, who has responded and investigated and followed up on some of these complaints. And if you would feel comfortable moving forward and hearing from Andrew Stewart, our building commissioner, I would just like to stress that you're the chair, you're in charge, you're running this meeting, and every time someone gets interrupted and shouted down, they're disrespecting you. And that this is a public meeting, and everyone has a right to be here. What they do not have a right to do is disrupt a public meeting. And if they continue to do that, they can leave.
I appreciate that, Steve. We all know that from time to time, people's emotions get ahead of them, so you kind of have to kind of give some leeway, some deference sometimes, Yeah, I mean, this paragraph is screwy. I think, my opinion is, I think it's supposed to say outdoors, but either way, so, I like Trish said, I mean, is there a compromise that can be made here in regards to the situation? Are you guys open to?
Well, I mean, I have a few problems with that. Is one, I don't see that, without any evidence of an actual violation, I don't see that there is any grounds for the express language of this to revoke, modify, rescind, et cetera. That said, I don't have a proposal in front of me, so it's impossible for me to respond to something in the abstract. I certainly don't want to sound as if my clients aren't interested. They're certainly active members of this community. I mean, if you read the notes from the June 10th, 2024 meeting back to May 19th, there's been numerous public support. Many, many members of the neighborhood have supported the Jetty's outdoor dining. So it's not as if that,
Yeah, I know, but the whole thing is that the one thing I would question, to be honest with you, is that, all right, yeah, the community in general supports it, but how many of them actually live in the vicinity of the Jetty that support it too as well? So, I mean, my look, are you all done? I just want to take one more from,
I'm
Mr.
happy to
Duffy.
stand down and let someone
All
else.
right, Mr. Duffy, are you going to read another?
This goes back about a few minutes ago, but it's talking about the parking, all right? So, yeah, I don't have a problem parking, I have plenty of parking, but my neighbors don't. And as you know, Brent Rock's a very tight, village-type neighborhood, and parking, especially in the summer, is incredibly tight. And am I affected by the parking? Yeah, I walk up to the Fairview, it's a great restaurant, but I can't walk on the sidewalk because all the cars are parked on the sidewalk. The cars are parked on the sidewalk because this town gave 14 taxpayer-owned parking spots to a private entity. And the only people who can fix that is this board. That was, what happened last June was wrong. This town should have never given 14 taxpayer-owned parking spots to a private entity. You guys can fix this, I hope you do. Thank you.
Mr. Duffy. All right, here's my look at it in regards to the situation. One is, Andrew, do you have anything to add on to this, or are you good?
I can answer any questions you may have regarding to any of the stuff they brought up about the zoning and.
Sure, Steve, do you have any questions for Andrew?
I do, yes. Could
Don't
you,
mind. Yeah, let him get up there.
Andrew Stewart, Marshfield Building Commissioner. So, go ahead. Steve.
no, go for it.
Yeah, I've received several requests for enforcement on this property over the years for sound, which we do have a meter to register sound, for light shining in, for all sorts of other claims. I've done enforcement against the Jetty. We've removed items that were non-compliant with FEMA regulations. They resolved all those issues. They have, when I visited it at night, I've actually seen more light coming from the street lamps, the metal halide street lamps, and the across the street at the Venus, or, you know, they've got lined lights going all the way along the whole thing. I think more light actually shines from there than does from the actual Jetty and into the surrounding houses. That's been my experience whenever I've gone down there at night. In regards to the notification, I can't speak to anything. I agree with Bob. We're responsible, you know, as boards, the zoning board of appeals. We've got to get the, you know, they got to get it in a butters list and show us that they're sending notification out. They have to do the same thing for the Conservation Commission. In 2019, the last time they came for site plan approval before the ZBA, they were approved for that site plan approval. They challenged it, saying that they did not receive the notification. The court denied that challenge and upheld that we did everything correctly. So that the continued bringing up that notification thing as it relates to previous zoning decisions really should not weigh on you. And then now you, like we've seen tonight, you do not have to give notification as a select board as far as this, your approval of extension of outdoor seating goes. I think personally, I never quite agreed with the select board taking over the process. The law says you may create a process, and we had a process. And I think that's where we kind of got mixed up, and now we didn't, you know, we're kind of in a gray area where there's some contention. If that could be resolved, that would be great. I'd love to help any way I can, but I think that as far as the actual history of, you know, the site plan approval, what was granted, and my perspective when I've gone down there and seen violations, you know, I've listened to Mr. Duffy's concerns. I've addressed several of them. When I have denied them, they've been appealed to the Zoning Board of Appeals, and the Zoning Board of Appeals each time has upheld my decision in that regard. So we have played this out under appeal many times in public. I think really what it has to focus on is exactly just what you guys are doing as far as the extension of outdoor seating. You know, the ZBA, the Conservation Commission, we still address all the same things we're supposed to: subsurface disturbances, blocking flow patterns, handicap accessibility, all of that kind of thing. But as far as the actual outdoor seating, what you guys do, that really is a different thing now than what we've done in the past. So Any other questions, I'd be happy to answer.
No, that was a helpful summary, thank you.
I have a question. Andrew, how many times did you take sound level readings? And did you document it?
Never and no.
You never took sound level readings?
No, every time I've been over there after 9 o'clock when they're supposed to stop playing music, they've played music inside, so
Okay, what about before 9 o'clock?
that's you would have to call the police, and, because we don't have a decibel
I
limit.
thought you said you had a decibel level meter.
I do.
Did you use it?
We don't have a limit in the town for music.
There's no, really?
No, there's
I
no
think
bylaw for that.
there's no, that's, well, maybe we should have one. The other thing is, there's a zoning, a bylaw that requires restaurants to have parking. It's a bylaw, right?
I think Andrew spoke to that in regards to the way the state law is written, how this has caused an issue in regards to, yeah, you get your zoning rules and.
I'll address that real quick, okay? Yes, we have zoning requirements for parking, right? The Jetty and the Bailey and other restaurants that were there beforehand, they have gotten special permits from the Zoning Board of Appeals to allow that use. Those special permits, right, and especially because it's a non-conforming property, right, and it's a non-conforming use for this area, they don't have to, the strict buffer of this 35-foot buffer that's just in the bylaw does not apply to this property, because it's been granted special permits with conditions to have that, to do that, so that there is no buffer. And I've explained that many, many times over the years. I've explained many of these things over the times. I agree that there's an issue with the parking. I think that the state law and the way that everything happened complicated that even more. Yes, there are requirements of parking, but where we are right now is where we are right now, and I think the board kind of has to make a decision as to where you want us to go in the future.
So I'm just curious, when was the 35-foot buffer and screening, when was that somehow disappeared? How did that not apply to this location? It applies everywhere else, doesn't it? I'm just curious, I don't know.
It's, all right, Mr. Duffy. You want to say
Parking
something,
is
Bob?
required in restaurants.
There was never a 35-foot buffer here. That building in the rear is located about 3 feet off the rear property line. The entire parking lot has been paved for as long as I can remember, and I remember when it was the breakers. There was never a vegetated buffer, and all there ever was a fence, and that's what continues to exist today. Look, at the reality is there's never going to be enough parking that's needed for all the businesses that are at Brant Rock right now. That's why we have a bylaw that also allows you to have off-site parking by special permit, and that's why the town has made available the beach parking lot at off hours for the restaurants to park in other places that are in close proximity. There's just never going to be enough parking down there. I do want to bring something else up. There is a state regulation for noise pollution, 310 CMR 7.10, when the noise pollution rise is above 10% over ambient, there is a state noise standard. I agree with everything that Andrew said. I think Andrew investigates every time there's been a complaint. If Andrew perceived a problem, I've never seen Andrew refuse to enforce an issue. If Andrew felt it was above that, he could request assistance from the police. The police do have decibel meters to enforce this. I've not heard a substantiated complaint. I don't know what hours the entertainment license allows them to play amplified sound to, but at the Fairview, they have the right up on the wall to play amplified sound until 9 p.m. And that's in more of a residential area than this area. Actually, the Fairview is in a residential neighborhood. This is the Waterfront Business District and the Brant Rock Overlay District, so it's slightly different than the area that the Fairview's in. But, you know, understanding there could be an adverse noise impact, prior boards of selectmen with the entertainment have limited to outdoor noise till 9 o'clock. In terms of what council said before, I think the conditions, number 2, the approval shall be effective as long as it's compliance with applicable state, local laws, bylaws, rules, and regulations, or said approval is no longer permitted by state or local law. That's number 2. The other one, I think council read correctly, and that has to do with suspension or revocation for violation of state laws, bylaws, or regulations. So I think there's two aspects of that. And I support Selectman Simpson's, Select Board Simpson's idea that there should be a discussion here and a dialogue to get this resolved once and for all, because no one is ever going to be happy unless there's some middle ground.
Is that Bob?
Yes.
All right. Steve, do you have anything to add?
I mean, what's the middle ground when there were 0 substantiated complaints? Where does the middle ground exist?
I understand, Steve. On that, that's it, Mr. Duffy. Trish, do you have anything to add?
No, I just, again, I did hear from other businesses and other people, and I just don't understand how they can double their occupancy and take that parking away. And if this is setting a precedence, and that's why I think it would be good for us to have communication and come to some middle ground.
Yeah, I mean, Trish, I don't necessarily disagree with you. The thing is that the Vons asked the select board last year in regards to this, and there was a majority vote of 2-1 that approved all this. And I do recall, and I believe read recently in regards to what Attorney Cullen brought up, and which I brought up in regards to the only way it can be rescinded is if there's a violation of the rules and everything like that. And that's where I'm looking at. And the whole thing is that I will say this to you, Mr. Duffy, because there's confusion in the language in regards to what I read here in the law, what Mr. Town Administrator Moran pointed out, but, you know, him and I have a different opinion on it, but where the local board is now solely responsible for approving amendments to changes in outdoor table service, only alteration on premises, but then after that goes amendments related to indoor alterations. And that's the problem right there in regards to the law. And I think what we need to find out is if that indoor is supposed to be outdoor. You have one more thing to add?
Just going to ask you, can we maybe ask the state? Can we ask the state for clarification?
I think that's what we're going to need to do.
I think that's fair.
So Bob, how do we?
There's no clarification needed. This law is crystal clear. This relates only to outdoor table service, and no notice is required.
It would be, yeah, I'd be happy to email them and say, is this written correctly, and find out if.
Yeah, because, I mean, you got outdoor, this is all specific to outdoor, but then we have an indoor thing here, so that's my look at it right now.
I think this is pretty clear.
Even assuming it was written incorrectly, my client relied on it when it went forward with that hearing. So respectfully, a year later, I don't think it's appropriate for the board to reconsider this on an unsubstantiated allegation that notice wasn't received by Mr. Duffy.
Attorney Cullen, I understand your concerns and everything like that. And, yeah, should the Vons be responsible for possible miswriting by the legislature, whoever wrote this up and all that? I do, but unless we get clarification in regards to it, you know, there is something in there that says notification to the abutters, but, I mean, my look at it is this.
But what form of notification? Because notification was provided through the town's website, so there was notice of the.
Well, it says abutters notification requirements, so what are abutters notification requirements?
It's not required under this provision of the law.
Right, that was the whole.
What am I reading here?
You're reading an advisory from the ABCC, you're not reading from the text of the law. The text of the law, and I have it on my computer, speaks nothing of this. Subsection B, such process shall not be required to comply with the notice and publication provisions of Section 11.
But it says Liquor Control Act, Mass General Laws 138. So is there, in Mass General Laws 138, is there a requirement in Mass General Laws 138 in regards to advertisement, abutters notification requirements in a local board hearing?
Absolutely, when it relates
All
to
right, so
the issue.
there's a law in it, right?
You kind of cut me off, so if you didn't cut me off, I would have explained to you that this is an exception, okay? This is an exception that became evident in 2024. And if you allow outdoor table service, you can allow it in this fashion without notice.
Yeah, that's where you and I are probably going to disagree on that. But yeah, here's my look at it, Attorney Collin, and I guess, I don't know what Steve and Trish are on it, but in regards to what the select board agreed to last year, unfortunately, I'm going to just keep the status quo of it until, unless something comes up, because I'm not going to be the one to, unfortunately, break something that was agreed to by a majority, unless otherwise said that we have a right to revisit it or whatever. So, are you guys, I don't know, you know, something, I guess, I'll have to look at how the motions are written here. All right, so it's in favor or against. So the only thing I'm going to have to say is, in Mr. Town Administrator Moore, and you can correct me, so should I make the motion saying all in favor of staying with last year's vote, keeping last year's agreement in place in regards to the jetty, or how do you think I should look at?
What I would say is no vote is necessary at this time, since you're not going to change you don't have a basis on which you could change the status of the permit that was granted, because you have no alleged violation on which to base it. So you don't have to have a motion on this matter right now. What I would, again, what I would suggest is, if it's the consensus of the board to have the parties, participate in some dialogue that the board wants to facilitate, to see if there's voluntary, not mandated modifications that could just quell this dispute and get it down to where we're not hearing from Mr. Duffy at every meeting, and the Vaughns don't have to hire a lawyer to come and address the concerns. I understand that it's volitional on everybody's part. The board's not forcing it, but it's better than where we are now.
Well, I would say.
And so I just think it's worth having a discussion. If it doesn't work, it doesn't work. But at least, we're trying to get to a common ground that people can, be neighbors.
I don't disagree with you. I would suggest, it's only a suggestion, that between the Vaughns, maybe, Mr. Duffy, and then if there's any outside parties that want to be involved in being a neutral thing, and then maybe there could be some agreement in regards to making some revisions, but right now, like I said, my hands are tied in regards to what was agreed to last year, in my opinion. As much as that I would like to undo it, I guess, and then revisit this and see if we can make improvements to it, unless our building commissioner comes up with a violation. I'm not saying that I'm looking for him to just go out there and look for one, but if there's a violation, then, then obviously that we can revisit this. I would just say to the Vaughns that whatever you have planned in regards to your alterations, just remember that if you're making them, whatever the ZBA approves, especially if they're permanent, I guess the nature is that, remember, if something comes up where this can be undone, you got to make sure what you do is not going to cost you a lot of money installing it, but then potentially removing it, I would look at. So that would just be my suggestions to you. So is that fair to say, Mr. Attorney Collin?
I mean, I don't want to say it's unfair, but it's also a little bit concerning, because part of the problem here is that decisions are made, businesses make,
That's why I made my statement, because.
Right, but that leaves them in somewhat of a limbo.
Look, even you agreed earlier that, to what I said was that if there's a violation, then the board has the right to revisit this. So the whole thing is that if a violation comes up and it's documented, then we do have the right to revisit it. So I'm just saying that whatever the Vines have proposed in regards to what they want to do with the parking area, just, be wary that you could put a whole lot of money into it, but then you may have to take it all down because something may come up, and it may not be me, it may be a board from 3 years now that may say, nope, we're all done with it, you're gonna take it all down apart. It's gonna cost them more money. So,
Well, this is what I think I'd like clarification though on. So are we firm on the fact that the board can only do that if there's actually a substantiated violation? Because this is my concern, is that there's a decision that's been made as of last year. My clients have made expenditures, have made decisions
Yeah.
for the future of their business based on that decision. And to the extent that that decision is now in limbo, quite frankly, my clients might be
Attorney
less
Collins.
willing to make that investment, and every other business in this community is going
Attorney
to be
Collins.
far less willing to make
Look,
that investment.
you have the language to what was agreed to by the select board last year. You even stated earlier yourself. So the whole thing is that you're their attorney. I'd say you can either take what I say to heart or, give them your best opinion what they should do. But I'm just letting the Vines know, as they are a business owner in the money they want to put into the business, that just be wary that if there's a violation, and it doesn't necessarily mean it'll be us three that's going to be up here. It could be a couple years down the road, if they still own the business, that something could be undone. So,
I'm just going to be perfectly honest. I find that statement to be rather concerning, because it really sounds like you're trying to dampen my client's motivation.
I'm not trying to do anything.
Well,
Listen.
again, I'm just saying that this is the way I take it, that it kind of sounds as if you're trying to dampen my client's motivation for doing that as a way of basically circumventing the issue so that we don't have to make a formal decision in here, because my clients will back down based on economic concerns.
I mean, if you want to take it that way, I guess you could, but my look at it is that as the Vines are a business owner in town, in my opinion, in regards to how the law is written, what you agreed to, what was agreed to earlier in regards to violations and all that, is that I think me, as being as fair as I possibly can as an elected official to both sides in this matter, is that I'm just letting them know, just be wary of what kind of plans you make, because it doesn't necessarily mean things can't change in the future. You know that, you spoke to that earlier, and that's all I'm saying.
If we're talking about a substantiated violation.
Huh?
If we're talking about it changed based on a substantiated violation.
Yeah.
Okay.
Yeah. All right, so I don't think there's any vote to be taken. I think everything's status quo. I appreciate everybody attending, and I hope that the Vines and Mr. Duffy can at least talk and see what can be done to resolve any, the outstanding issues, I guess, that seem to be still surviving and all this. So I thank you, Attorney Collins, for coming in and speaking to us.
Thank you, members of the board.
Thank you. All right. And thank you, everybody else. All right, Andrew, we're going to have you up, pal, for the discussion and potential vote of the stretch code bylaw with the building inspector. So I don't know if I asked, you sent out an email with 3 subject matters on it. I did ask IT to put them in so they could pull them up on the screen if need be. Do you feel the need that would be recommended, at least for yourself and the public, to view what we're discussing in regards to?
Well, yeah, sure. First of all, Andrew Stewart, Marshfield Building Commissioner. I just was informed that you wanted to talk about the stretch code and I have a vote. I don't know what the vote would be on, but that's why I really wasn't sure about what you wanted to talk about the stretch code. So
Well, I'm looking to be more informed about it, but also, I do have concerns. So, I mean, it doesn't necessarily mean that there's going to be a vote, but the whole thing is that I'm looking to if we should keep it or not, because in my opinion, when the former town administrator was here, he used to send out notices in regards to your work and all, in violations, I believe, that he sent to us that you came across. And I think some of them were in regards to not following certain things, if I remember. And I think the stretch code was on some of them. So it's my understanding, it seems like the stretch code is putting an expense on people when they want to remodel or do something to the house or whatever. So I'm just wondering if it's something that we should keep or not, and maybe you can clarify my thoughts on that in
Yeah,
regards to it.
no,
So-
I'd love to give you some clarity on that, because I don't think that that's actually the case.
Okay.
And I also, there are some people from the Department of Energy from Massachusetts here on Zoom.
Okay.
They're also prepared to comment, ask questions, and potentially give a slideshow if necessary as well.
Okay.
The stretch energy code, basically, so let me just start out. Massachusetts has a building code, and in that building code, there are energy efficiency provisions. So this is basically how you heat and cool your house or structure, and how that energy is generated, and to do that heating and cooling. And the goal really is to make that as efficient as possible. So we're not using up a lot of fuel to heat the houses, and we're not costing, so that you're lowering actually usage costs is ultimately the goal. And also lowering emissions, all sorts of stuff. And making the houses more efficient for heating and cooling. So that's really the goal of these codes. So we have, in Massachusetts, we have a base energy code, we have a stretch energy code, and then we have a specialized stretch energy code. So the base code is just that, it's what's in our building code. And in Massachusetts, we modify our building code, the state does. We add certain amendments to it to kind of personalize it to Massachusetts. And what we have done in Massachusetts is we have adopted the International Energy Conservation Code. We're currently operating under the 2021 version of that code with amendments. And those amendments are actually in the form of, that's the stretch code, right? Is that we're operating under, is those amendments to that code. There are so with the stretch code, basically in 2016, the town voted at town meeting to adopt the stretch code as their official energy code that we would use here in Marshfield. So currently, I think there's 301 towns in Massachusetts out of 351, thanks, right, that are operating under the stretch code. So we've been operating under it for 9 years. I've gone from somebody who was a laborer to somebody who was a custom home builder to now somebody who is on the regulatory side of the stretch code. So I've seen all the variations and how it affects residents, how it affects laborers, how it affects contractors, how it affects suppliers, and I see how it affects us on the regulatory side too, right? Ultimately, the goal is to make things more efficient, to lower costs, to lower emissions, lower our impact on the planet. It is part of a larger agenda of protecting the planet, climate change, lowering global emissions, part of that, the Global Climate Act, I believe, and it's part of the Massachusetts agenda to become, net zero by 2050. So it's all a movement towards that. And when you mentioned the violation aspect of it, right? So when the stretch code first came out, I think a lot of people were really confused. There were some pretty drastic changes as far as the amount of insulation that had to happen. And I think there was a lot of confusing language, and people were worried that the gas was going to just completely get eliminated in Massachusetts. All the houses were going to have to be completely all electric. That if you did an addition to your house, you'd have to gut the whole thing and change everything. And I agree that at the beginning of the stretch code, the updated one that came out a couple of years ago, that there were some confusing aspects, and there were some things that maybe were a little overreaching as far as people thought. And yes, I did enforce some of those. And through the appeal process, through the Building Code Appeals Board process. So when somebody disagrees with a determination or a decision that I've made, the proper thing is for them to file an appeal with the Building Code Appeals Board. And so they did that in this case on a couple of occasions with the stretch energy code and some determinations that I made. And the Building Code Appeals Board overturned my decision and allowed the people to, they said, well, it wasn't that extensive an alteration and really you don't have to do this whole house kind of change, So they're the right board to kind of give those, that relief. And I think they were giving relief quite a bit, and the Department of Energy regulation also, they had public comment period about a lot of these things. And so they updated the regulations last year and then again on February 14th of this year. And a lot of those regulations had to do, the updated regulations had to do with the amount of energy or the amount of insulation that's required in the ceiling or in the rafters. They decreased the requirement for the stretch code communities. They made it so that we kind of went back to older levels of the energy efficiency ratings that we do for ADUs or for large additions or for large alterations to a house. So they kind of revisited a lot of that language so that if you're renovating half of your house, you don't have to renovate the whole house or bring it all up completely into compliance. There's square footage, conditions within all of that, but, it made it so that it wasn't such a drastic whole house gut and remodel situation. And then they've kind of clarified some of the remodeling codes, such as, it used to be like if you opened a cavity in the wall and there was no insulation, the code just said just fill it with insulation. But now they've gone back to that and said, well, we want 3.7 R value per inch in that wall. But if it's a 3.5-inch wall, an old 2x4 wall, that requirement is still just an R13, which was the value of the R value that we've used in 2x4 walls since, the early 2000s and whatnot. So it provides now a little bit more reasonable stuff for remodeling or fixing things, so that you're not having to bring it up to new. But what it is doing is that everything that is new and everything that is extremely large, the code is trying to make it as efficient as possible so that we're not using up all that energy, and also so that people's energy usage costs are decreased over time. So that's really what I feel the stretch code is about. And I think that they've been very receptive in the last 2 years to hear our concerns as building officials, to hear contractor and designer concerns, to look at these appeals that have happened over the years. I think 2 of my decisions related to this stretch code have been appealed. I know that one in Hingham was appealed, and I know that there's been many others, and I think that kind of drove a little bit of these changes. And they've been really receptive at making those changes and getting our feedback and input. So I've been pretty happy with the process, and like I said, there's some folks online here from the state. They'd be happy to answer any questions as well.
So, all right, so the current stretch code that we're under right now, this is a town meeting approved item. So if there was to be any changes to it, whether adding or eliminating it, it would have to go through town meeting.
No, there's a provision in the article that says, and in fact, back then, the stretch code was under the building code, which is 780 CMR, Commonwealth of Massachusetts regulations. It's now under, I believe, 258 CMR, 225 CMR. Which is the Department of Energy regulation, so that it changed it so that they are the ones that are creating the energy code for the energy efficiency codes for Massachusetts. But the building code references that, just like we reference 521 CMR as our handicap accessibility code. So, and just as we reference 248 CMR as our plumbing code and whatnot, it is just the code that we are using for our energy efficiency, and it's just managed by the Department of Energy Regulation.
All right, so let me see if I'm understanding this. So the current stretch code we're under right now, is that approved by the select board, or is it a
No,
state thing?
it's approved by town meeting, so it was voted in at town meeting, and the language of that article says that, you know, this is the stretch code, we adopt it, and we are going to, Bob could probably get the exact language, but essentially it will be as amended in the future. You continue to accept it even as it is amended going into posterity. So the stretch code and the building code, I mean, the building code updates every 3 years or so, or we'll do updated amendments. We don't go back to town meeting and say we're accepting, you know, this code all over again. The language in that article said we are choosing the stretch code as it is right now, and as it will be amended in the future to be our energy code for Marshfield.
Okay, so if I'm understanding this right, so by the way it was, sounds like it was worded at town meeting, was that we're gonna apply the stretch, we're gonna accept the stretch code, but the whole thing is that now it allows the state afterwards to make amendments that would automatically take effect without any discussion at town meeting, nor the select board or anybody else.
That's correct.
So how much was added on since the initial acceptance at town meeting for this at the state level, I would imagine? Because
Well, we've gone from the 2015 International Energy Code, and then we went to the 2018 International Energy Code. Then that code was amended. Then we went to the 2021 International Energy Code, and that's been amended 2 times, or 3 times since then. So the language of the article says the town of Marshfield has accepted and adopted the provisions of the Stretch Energy Code as may be amended from time to time in place of the provisions set forth under 780 CMR. And we could update that to include the current language of 225 CMR, you know, 22.0 and 23.0. But it does say right here that it's the stretch code and it as may be amended from time to time.
yeah, I have, and it's probably not something anybody thought of, you know, I was probably there as well, is that's my concern, is that we have loose language in that approves something that looks okay, but then we don't realize the future impact, especially when it's being amended, and from the sounds of it, it's been amended 6 times roughly,
Sure, yeah.
right? So,
Well, I mean, since 2015 or so.
yeah, just judging by what you said, it sounds like about at least 6 times it's been amended.
Well, it's changed, the code book changes, you know, so just like our building code, we were operating under the 2009 International Residential Code as amended, and then amended by Massachusetts. And then we went to the 2015 International Residential Code as amended, and now we're on the 2021. And, you know, so every several years, the code gets updated and amended by Massachusetts. And the energy code is just part of that. Now, if we were to not have the stretch code and just go by the base code, so we would still be going by this book. We just wouldn't have these, you know, extra pages that are specific, you know, amendments to parts of this book, but we would still use this same book regardless. There's just specific things according to the stretch code that apply, that are amended in here. One example I will give you, we have for like the difference between the stretch code and the base code. So if we were to just use this book and not use the stretch code.
So when you say that book, meaning just the base?
This is the base code, yeah, the base energy code. If we were to use this and you were to build a brand-new house, right, your R value, or the insulation value for your rafters in your attic would have to be an R60, okay? And that's, well over 12 inches of foam insulation, closed foam insulation. Or it's about 10 inches of foam, like the hard closed cell foam insulation. That's just the foam. Imagine what you have to get for, fiberglass or, loose fill insulation, you're talking several feet, right? In the stretch code, you only have to have an R49, so that's only 7 inches of the, or less of the closed cell foam. So the base code without amendments, in some places of it, actually makes it more strict than the stretch code.
Yeah, it seems like, to me, it seems like,
But the stretch code is one of the codes that's kind of more adapted specifically more to Massachusetts. Much like we take our residential code and you've got the international code and we adopt certain things to Massachusetts. So it's very similar in that regard, where kind of certain things kind of make more sense for our climate, make more sense for, our region and kind of the different energy things that we encounter.
well, let me ask you this much, because as you mentioned that, it's an international energy code, I believe is what you called it, right?
The International Energy Code, yeah.
Why is it international? Why is it not just based like Massachusetts? Like every
Well,
state has its own thing. Why is it, is this a global initiative?
No, it's a company called the International Code Council, and they develop building codes. And they just call themselves the International Code Council, and those codes get adopted, yes, by a vast majority of countries and the states.
Yeah, so this
all
is-
sorts of.
this is like a
it's not
global-
necessarily I wouldn't call it a global initiative. If you really look at any
I would.
code or a building code, any building code really comes along because somebody died or got hurt, right? It's all about public safety and safety, right?
Though
So a lot of that stuff is just, it's kind of consensus, right, on how to keep people safe.
Well, as you say, I understand codes will change with public safety issues. So where does energy efficiency come in with public safety, I guess? Because you have this international energy code, you said there's like this international code council that I don't think anybody really knows anything about, but they're I guess, making some, I guess you can almost say it's somewhat law-like amendments, because all these, that this is the way these things start out, in my opinion, is that, oh, it looks all good, but now we're amending. And like you said, the base code seems to be stricter than what the stretch code is in regards to certain functions of it. And so the whole thing is that I'm just trying to figure out why you just couldn't make changes to the base code and be done with it at that level without having the stretch code, which we've opened up a can of worms, in my opinion, in regards to the language in it, in regards to being able to make amendments, because the whole thing is that without me knowing the amendments that were made at the moment, we could be going down a road that wouldn't be good for anybody, between a builder or a resident or anything else like that, in my opinion. So I understand codes are good, especially in regards to the safety and all that, but what is it with the International Energy Code? What would be the basis on safety on that, by us having this?
Keeping your,
I'm listening here, I'm looking forward to hearing somebody.
I would say maintaining heat and cooling where you live is pretty important to surviving in this climate.
Well, yeah, but I mean, let's put it this way, Andrew, I don't disagree with you, but it's to my understanding, just an example from what I've heard from some people, is that if you go with the all-electric, what's the Mitsubishi things everybody's putting in right now? The heat pumps, or what are they called?
They have heat pumps, they have mini splits.
Mini splits, I think. All right, heat pumps and mini splits, right? So, correct me if I'm wrong, but I've heard from one or two people saying that yeah, when you put those in, you're required to cut the wires in your thermostat and disconnect your furnace from the oil or gas and everything like that. So, I mean, is that true? Is that if you go with that and you want the rebate back, that you have to disconnect your thermostat from your furnace?
Well, I mean, you're talking two different things. Are you talking what you need to do in order to get a rebate back from the state?
Yeah,
Or
well,
are you talking about what you need to do according to the building code and the energy?
No, rebate. To my understanding, it's a rebate.
So I don't handle rebates, I
Yeah.
don't deal with rebates, it's not, I deal with the code, and what you want to do, is it allowed under code? And I'm going to do that. If you want to deal with rebates, then, and take extra steps and do extra things that will get you rebates according to the programs that are offered by the state, that's kind of your own initiative that you.
Well, I look at it as this, Andrew, is that it's like anything else. They'll baby step, they'll rope people, start roping people in, and as soon as you get a certain amount, then let's put it this way, then they'll take the stretch code, right, and the amendments, as soon as they get enough people that are roped in because they want this rebate, then they'll force it upon all of us in order for us to potentially not have fossil fuels in our house if we chose to have that. So that's the way I'm looking at the moment in regards to this whole situation. This is my concern with the stretch code, especially as you mentioned that they could put amendments in, and it's unknown to the public what amendments are being put in, especially when they don't have to be filed by or approved at town meeting, because we're going to get something that everybody's unaware of, but the whole thing is that when it comes, then all of a sudden, everybody's going to be not happy about it and everything. So these are the dangerous things that I think going forward that we need to be very wary of in regards to these kind of situations.
Can I make a quick comment?
Oh, go ahead, Andrew, absolutely.
So the amendment process, as far as codes, especially to the stretch code or building codes, is actually very public. They post all sorts of information on their website. So does the Board of Building and Regulation of Standards. In fact, I post information on my building department website whenever they have updates to the codes. I've announced public comment periods. They have asked for public comment. It is a very public process. It starts at the state level. So, you know, as a concerned citizen who is in a stretch code community, I would encourage you to keep abreast of those changes. And then if those changes are that concerning to you, to bring it up at town meeting to change our bylaws. But in this setting, I really don't know that we can do a whole lot about it. But I will say that I feel like their process is very public. It goes through multiple committees. It goes through the Board of Building Regulations Standards. It goes through the Department of Energy. It goes through the state legislature. You know, it's a very public process, and it's all out there. There's tons of information. We've got 2 representatives here from the state that'd be happy to talk, I'm sure, about all of it as well.
Chime in. Like I said, we know what Governor Maury Healy's initiative, as well as everybody else's, that they want this whole green energy thing, eliminate fossil fuels and all that. And I just look at the stretch code as a stepping stone to doing that, as well as other initiatives in order to facilitate what their goals are, in my opinion. If the 2 guests on Zoom would like to speak on this matter, please do.
Yeah, I'm happy to speak a little bit more in detail to the life safety piece of the benefits of the energy code. So, hi everyone, I'm Michael Rossi, and I'm an energy code specialist with Performance Systems Development. So, we provide energy code training and technical support on behalf of the Mass Safe Code and Standards Compliance and Support Initiative. So, when it comes to life safety, one of the benefits of the stretch code as opposed to the base code is a lot of the new construction projects that go through the process are third-party certified, meaning that someone goes to the site and actually looks at the quality of the installation, makes sure that there's no deficiencies in terms of what's being used for different installation assemblies, making sure that with the way it's insulated, there's not going to get like water or vapor coming through the envelope and potentially causing any mold or mildew problems down the line, making sure it's properly air sealed to make sure you're not wasting energy. And additionally, a big part of it is indoor air quality. So one of the pieces of the stretch code that's not in the base code is actually the inclusion of using a balanced ventilation system, either through a heat recovery ventilator or an energy recovery ventilator, that's intended to provide very good indoor air quality because it essentially brings in fresh air from the outside while also removing stale air from the inside. So as opposed to a typical exhaust-only type ventilation method for the whole home, typically like a bathroom exhaust fan or something, you have this more balanced system that does help when you're tightening the building envelope. So when I think about energy codes and like safety, I think about it from the perspective of better indoor air quality, less mold and mildew accumulation, making sure the systems are working properly because of third-party certifiers going on site, making sure that everything's like designed as planned, and really being able to analyze those specific features of it and sort of act as a coach to the builder to make sure that they're doing everything effectively. So, and in addition to that too, I'd also say that as Andrew mentioned, there was the retaining the heating and cooling loads. That's actually a really big piece of this as well, because resiliency is a really big benefit of energy codes. So in the case of extreme weather events, power outages, things like that we might get, with some of the extreme winters we tend to have en masse. Typically, the thermal envelope of these very well-insulated buildings from the energy code tend to keep the temperature more consistent over longer periods of time. So it sort of increases this thing called passive survivability, which is essentially like the ability to maintain comfort and survive, like being able to survive in a building for X amount of time after a disaster. And there's been studies done that show that building to the most recent energy codes increases passive survivability, so allows people to shelter in place longer during these kinds of disasters and things. So when it comes to the safety pieces, that's what I can speak to in the stretch code. Thanks.
Thank you.
I'd like to just mention, thank you, Mr. Chairman, for allowing us to speak. We have to be recognized, and that's our goal, is to be recognized in order to speak to you, so we're not interrupting your meeting. Andrew did a great job talking about the code.
Can I get your name and your address?
Lisa Sullivan. I'm from the Department of Energy Resources. I'm your Green Communities Program Coordinator. I work for the Commonwealth of Massachusetts for the Department of Energy Resources, and I work closely with the town of Marshfield, Fred Russell and Tony Bullock. We've given away to the town over $1 million to fund energy efficiency projects in your municipal buildings. We've done work in 4 of your schools, your town hall, your fire stations, your senior center, your library, and that's how you spent that money. And you also received mass save incentives for all of those projects to make the money go further. So you have been making good use of the Green Communities Program through your facilities team, picking out, projects that will make a difference. And I know you do a lot of things on your own as well. And what I wanted to just comment on is you are correct that if you were to want to rescind the stretch code, you would have to do that through a majority vote of town meeting. So you rescind in the same way that you adopt. And you did adopt the stretch code, as did 301 communities at their town meetings or via their town council votes if they had a town council form of government.
Thank you. Do you guys have any questions?
Well, you go first.
Thanks. I just have one quick question. Just in relative terms, given how new the stretch code is relative to how long the building code has been around, do you feel like we're still at the point where there's a lot of latitude or not a lot of uniformity in how it's interpreted at the local level, or do you think for the most part everyone's kind of on the same page and there's some uniformity in the guidance?
Yeah, I can speak to that. Just like with any building code, especially updated building codes, and I honestly think I have a different perspective from a lot of other building officials. I am a bit younger than a lot of other building officials, and there's a little bit of you can't teach an old dog new tricks in the business. And so, yeah, I think that there is a little bit of an issue with uniformity of how building codes are administered between municipalities. However, here in Marshfield, it's my goal to be as consistent as possible with the codes and to get the best training for me and the building inspector so that we are properly administering them and doing them equally and consistently, with the best guidance that we can get. I can't obviously control how other towns are doing it, and I get that all the time. Well, they don't make me do this here, and they don't make me do that there. And, I say I understand that, and that may be how they handle it, but here, if you don't want to do it that way, you're gonna have to appeal it to the state and go that route. It's because that's the fairest, most consistent way I can do it.
Thank you.
Yeah.
Being the expert here, do you feel that this stretch code is needed?
I'm not going to give my personal opinion on the stretch code, quite honestly. I don't think it's appropriate. I think that, it is our code, and like I said, I'm going to administer it fairly and equally, and, I'll let that, my vote at town meeting speak for, the stretch code, whether I support it or not. As far as, whether I'm going to administer it, yeah, I am. I have, obviously I talked to a lot of contractors, I talked to a lot of people in the business. There was a lot of concern at the very onset that this was going to greatly inflate building costs and really make the projects, quote unquote, impossible. And I will say that I have not found that to be the case over the last couple of years since these updates have been made, that people have been able to reach these energy efficiency levels, that it hasn't greatly increased the overall cost of these buildings, and that the market has kind of worked with it. All of these companies that do all the insulation now are so well trained on the air sealing and all the different things that they have to do. It kind of makes our job easy as inspectors nowadays when we get the companies that do everything according to the code, and know that they're going into a stretch code community, know that they have to do it a certain way. They're actually making it very easy on us. And the feedback I get from residents are that they like their insulation, they can't hear the noise from the street, they are warm in their house. It only takes a little bit of, a little extra heat or manipulating something to kind of warm everything up and keep it warm. People do it all different ways. They may have radiant heat in the floor, they may use a little gas fireplace. It doesn't mean gas is not illegal. You can still have gas, you can still have mixed fuel buildings, you could have your whole house run on electric heat and then just have a little gas log in the corner. It will affect how your house is rated as far as what efficiency rating your house has to get to, but you can still do it. And contractors doing it all the time here in Marshfield. And I haven't really, we had the initial kind of gut reaction, knee-jerk reaction about how horrible it was going to be, and I have not seen that actually come to fruition in this town.
Thank you.
On the, in regards to the amendments part, in regards to what's in the town meeting article, I'll look into it more, but is it possible that that could be stricken from the article? Future add additional amendments to it, and then if anything comes up, it'll have to be approved at town meeting?
I would imagine so. If you proposed an article at town meeting that changed the language of the general laws, yeah.
Okay. I appreciate it, Andrew, thank you.
Sure thing.
I'm not gonna take a vote on this, I just wanted to get more information on it. I appreciate Andrew for being here.
I just want to thank the folks from the state too for.
Yes, the state as well.
I appreciate
Thank you.
it. They do a lot to support us. They answer our questions really fast, and they give us really good guidance.
Thank you, Andrew, for your time.
Thank you.
Okay, number 3, discussion vote regarding opposition to legislation to eliminate the North River Commission. Have you guys received Mr. Kearney's letter?
Yes.
And I'm not going to ask for a vote on it because I've spoken with Mr. Kearney, and he's had told me some things that are concerning in regards to some of the people that I guess are along the North River, along the North River itself, in regards to supposedly how the members that I guess oversee it have handled some issues, I guess, up there. I guess that's the concerning issue with Representative Kearney in regards to this matter. So I will read this letter from Representative Kearney. Dear members of the Marshfield Select Board, this is dated June 9, 2025. I hope this message finds you well. I am writing to share information about legislation I have filed that proposes to eliminate the North River Commission and transfers responsibilities to the municipal conservation commissions of the towns along the North River, including Marshfield. This proposal is based on growing concern that the current structure of the NRC is not serving our communities as effectively as it could. The commission operates with only one part-time staff member and depends on the Department of Conservation and Recreation for legal counsel and enforcement. This limited staff and external dependency have led to delays, inconsistency, and a lack of clarity in permitting and enforcement processes. In contrast, local conservation commissions are better positioned to manage these responsibilities. Municipalities like Marshfield have full-time professional staff, access to in-house legal counsel, and a deep understanding of local environmental community context. They already enforce environmental laws under the Massachusetts Wetlands Protection Act and are fully capable of ensuring continued protection of the North River corridor. Additionally, there have been increasing concerns from residents and officials about the actions of the NRC. In several instances, the Commission has taken enforcement actions such as placing liens on private property, and in some cases, acted outside of its jurisdiction as defined by the North River corridor boundaries. These actions have caused unnecessary confusion and hardship for residents and have strained public trust in the process. As someone who spends a great deal of time on the North River, whether on the water or enjoying the surrounding landscape, I care deeply about the health of the watershed. This river is a vital natural resource and a defining feature of our region, and I am committed to ensuring it is protected in that way that is both effective and accountable. There will be public hearing on this bill in the coming weeks where residents, town officials, and stakeholders will have the opportunity to provide testimony either in support or opposition. I encourage everyone with an interest in the future of the North River to participate and make their voices heard. My goal with this legislation is to restore trust by placing responsibility in the hands of local officials who are directly accountable to the communities they serve and who have the capacity to carry out this important work efficiently and transparently. Thank you for your continued commitment to responsible governance and environmental stewardship. Please don't hesitate to reach out if you have any questions or would like to discuss this bill further. Sincerely, Patrick Kearney, Representative, 4th District, Plymouth County. So, and that said, is there anybody here from the North River Commission or from Conservation that would like to speak on this?
Craig Hannafin, 1317
Craig, you
Union
could-
Street.
Those two, okay, you got it worked out? All right,
Go
go
there,
ahead.
yeah.
There's three of us.
I am here as a private citizen, the chair of the Marshfield Conservation Commission, and a board member of the North and South Rivers Watershed Association since 2007. Do you have in front of you the letter that the Conservation Commission voted on last week?
Yes.
I take exception with Representative Carney's concept of what conservation commissions do and what the North River Commission does. The North River Commission has been here since 1978. It protects the river corridor 300 feet on either side, which is a much greater protection than any of our wetland properties are afforded under the wetlands protection. I have, and I will give you, a copy of everything that took place before 1978, when this act was voted in. With respect to, well, I will let Ms. Leonard speak with respect. She is the Marshfield representative to the North River Commission. I think it would do a huge disservice to the town of Marshfield and the 8 other towns that are involved in this act. This is a regional resource, and it needs regional oversight and protection. I'm going to let you respond to some of the direct comments that he made in his letter.
Yeah, I don't really know how to respond to it. I think if you've never been up the North River, you need to see it. I've tried to get a meeting with Rep. Kearney twice. The first time I met with his assistant, and she was setting up a meeting so that we could meet with him, because he has not come to us. So we really do not understand why he has put this to abolish the commission forward.
Well, just not to cut you off, but in his letter here, I think he states,
But that was the first I've heard of that letter. I was talking about me getting, him coming to the commission and saying what he said there to us. And he has not come to any of our meetings or even addressed any of those concerns with us. He went right to proposing a bill to be voted on at the state level.
okay, so what you're saying is prior
I just heard.
to him doing this, he has not
He has
had
not
any conversation with you on it.
So if you haven't been up the North River, I would welcome you. We will take you for a ride up there to see what we do for the protection of that North River. The town is so fortunate to have the North River. We also have the South River, which is absolutely beautiful. But if you go up 2 rivers, you're going to see what the difference of the protective order does. We, as Craig has said, our jurisdiction is a little bit different than what the conservation has. We are 100 feet from the natural bank where there is no building, unless there's something already there that was there before the protective order of 1978. I think some of what, is like this board. You make a decision, you're going to have people that agree with you, you're going to have people that disagree with you. I mean, it happens. And sometimes what we are trying to do is administer the protective order. It's not us saying, no, you can't do it. It's the protective order that says, you're within the 100 feet. You can't do that. That's what we're trying to, that's what we're privileged to be able to help, to be able to help protect the river as you see it. I think if you went along the towns, we have 6 towns, starting with Situate, Marshfield, Hanover, Norwell, Pembroke, and Hanson. So I think it's 6 miles. Bill, you can correct me on that one, if it's 6 miles up the river. If you were to take a survey of all of the individuals that live around or on the river, you would get such a high approval rate of what we do. They understand that we're protecting their property rights. We have people that will do just, they'll come in and they'll do what they want, or want to do what they want. It's their property. Yeah, but it's also all of our property. So when something is there that we cannot approve, we just can't approve it. We don't have a lot of, what's the word I'm looking for? The most that we can do is put a lien on their deed if they do not comply. That's all we can do. We don't have enforcement rights in that right, that we can't fine them or do anything like that.
Who would place the lien for you?
Our administrator would just go down to because if someone, say, is in an area where they're required to have a special permit, if we deny the special permit because what they're trying to do is not allowed by our protective order, but they go ahead and do it, or whatever, then we can put a lien on their deed. Now, today, I don't know. I mean, if that even makes a difference to a lot of people that want to buy a house, because if a lien is on a deed, from what I understand, that just keeps going to whoever owns the house. So even though if the person who buys the house, they inherit that problem. But it's one of those things where it's, That's about the most that we can do. What we're trying to do is what we're trying to do for the river, or what the protective order is saying, is it's for the scenic view. It's so that when you ride up that river, you can go on parts of that river, and you might as well be in upper state New York or up in Maine, because there's places that you don't even see another house. It's absolutely stunning.
Let me, I'm not saying that I'm for or against, but I do have to ask is how come the Conservation Commission doesn't have, I guess, control of this area, which I mean, I would look at that as something that they probably would be well within their responsibilities. Well, how come there's a special commission to oversee this?
I'm going to let Bill answer that, because he was in this from the beginning.
Right.
Let me first, I brought you a handout. My name is William Finn, 96 Dog Lane. I'm a special consultant to the Conservation Commission, and was one of the people who helped establish the North River Commission. And I'll give you this article. It was published in Lawyers Weekly several years ago.
Thank you.
But it's a description of, a concise description of
Thank you, Mr. Finn.
the North River Commission.
Thank you.
Begins at the end of the first column. You can read that at your leisure, but the difference is primarily the North River Commission is designed to protect the scenic value of the North River. The wetlands, the Conservation Commission is designed to protect resource areas that include all kinds of wetland values and resource areas. So the Conservation Commission has a much broader mandate, and the Conservation Commission does have authority on the North River. It's not like they don't have authority, it's that this is an overlay, if you will, on the Wetlands Protection Act. The Wetlands Protection Act does not specifically give a lot of authority to conservation commissions regarding scenic value. That's not one of the resource areas that they have jurisdiction on. So, and the North River Commission regulations are really zoning-based regulations, because when they were developed, we didn't have the Wetlands Protection Act that we have today. This was developed in 1978, and I happen to know that because I was chairman of the Rules Committee that developed the regulations of the North River Commission. And I think Craig has with her the report that was developed, and I think we're going to leave a copy of that report with you so you can all read the report that goes through the whole history and who was involved in the development of the North River Commission, how it was developed, who was involved. There was, I mean, a myriad of people involved. I just happened to chair the regulatory portion. But that's the report that was prepared by the state. I was a little bit surprised to hear Representative Carney's letter this evening as well. He mentioned there's a hearing that's going to be held shortly. My request to the board was to, if there is going to be a hearing on this bill, please let the Conservation Commission send a representative to that hearing so we can testify at the hearing. We would like to know when the hearing is going to be held, who's going to hold it, and what committee is going to hold it, because we would definitely like to testify. So that would be my request to the board, not to make a decision.
My look at it is that I'm not going to prevent, us as a board, I would imagine, certainly not I, is not going to prevent a commission member to go testify in something that.
Well, apparently, Mr. Representative Carney is communicating with you, and I'm just saying, if you would pass that information on, request him to let us know when the hearing is going to be, and you let the Conservation Commission commission know, we will go to the hearing.
Okay, so all you're looking for is just information in regards to meeting date and time.
Right.
And then.
If you could just let us
me
know
inform
that,
and then you'll be there.
We'll take care of it.
Yeah, either you show up or, I don't know if they do a Zoom there or not or whatever, but,
We'll be there.
okay.
Representative Carney has not communicated with any Conservation Commission that I know of. He has not communicated with the Marshfield Conservation Commission. I don't believe he has formally informed the North and South Rivers Watershed Association of this pending hearing either. They are the pass-through organization for the funding that comes from the state through DCR. And with respect to that funding, I would imagine if the North River Commission is dissolved, I don't know who's going to carry the burden of the administration of this and the River Patrol. The Town of Pembroke Police Department currently patrols the river during the season of most use. And
Well, you do get funding, I think, every year you get funding? And part of that funding,
DCR.
and part of that funding is to fund the river patrols?
Yes.
I imagine, so I would look at, depending on what Representative Kearney's, I guess, goal is that, I would imagine that, let's say, there was agreement to dissolve the North River Community Watershed Group, that funding would probably flow to, what do you say, the 6 communities involved in this?
There's 6 towns.
6 towns? Yeah, so 6 towns, I imagine whatever monies you get may flow to each of those towns, but I don't.
well, the line item currently is $50,000. If you're going to start chopping and slicing and dicing that between towns, I don't think that's going to work very well.
It may not, I'm just saying, just giving you my thoughts.
Mr. Kelly, so I'm sure we're all familiar nowadays, particularly in Marshfield, with the words unfunded mandate.
Oh, I think we're all very well, very familiar with those words, yes.
I think that's what you're looking at here.
Okay, all right, Mr. Finn, it's a good point, and is well taken and under advised, absolutely. I would say, yes.
Just to give you an update, it was the bill House number 4110 was referred to the Joint Committee of Environment and National Resources on May 25th. No hearing has been scheduled yet.
Right.
No hearing has been
Not yet,
scheduled.
right.
I would be surprised if it sees the light of day, but we'll see.
Yeah, I would just ask Mr. Moran that if you can reach out to Representative Kearney
We'll find
and
out.
say if there's a date and time set to inform us, so we can relay it to Mr. Finn.
Well, it's the Conservation Commission, and they'll tell me what they want me to do.
Okay, at least, conservation, anybody that wants to be informed, but certainly, definitely let conservation know, without a doubt. So, Steve, do you have anything to ask? Comments?
No, I think you pretty much kind of hit the nail on the head earlier. It's just an important update to give. We don't have to take any action or votes tonight.
Yeah.
I don't think you need us to vote to authorize you to speak at the hearing in your capacity as a member of the commission. And I just want to congratulate you because I can see a headshot of you from 7 years ago. You look pretty damn good, so I hope I can keep pace.
So, may I, and I'm sorry, I did not introduce myself. Mary Ann Leonard, 70 Damon's Point. I am the representative on the commission for the town. So, well, 2 things. One, there's been usually we have an alternate. We haven't had an alternate for years. And I've been told the 2 names have come in front of you. Hopefully you can pick one, pick both, and, get them certified or approved so that they can be with us. And also, I hate when I forget what I was going to say. I know. The other towns or the other commissioners for the other towns have also gone to their town conservation and have also gone to their town's Board of Selectmen, and have asked that they write a letter in support of or in support of the North River Commission and not to approve abolishing us, and that's what I am also here to ask you to do. So I will ask if you would also write a letter to the state, to whoever you need to write the letter to when we have a bill in front of us like this, of not abolishing the North River Commission. So I guess, I
All
don't know how
right,
you know that.
before we get there, I just want to ask, you're all set with your questions and everything like that, right?
Just based on one comment, just one quick
Go
thought.
ahead,
Your mention of alternates, like the ZBA and the Conservation Commission are two of the most subject matter dense committees we have in town. And I think it's great that we have alternates because people get time to kind of take things in because it is very complex. So, yeah, we do have some applications that came through, and it'd be great to get your thoughts because, I'm not familiar with everyone in town, so it's good to know if you guys are aware of them and their background, and if they would be a good fit and what your feedback and thoughts are. So it would just be great to get all alternate slots filled, and again, those are two of the more complicated committees we have in town, and I would flounder on the ZBA and conservation, so thank you for stepping up and serving on those. But yeah, we'll get those to you. It'd be great to get your thoughts, and yeah, thanks for coming in tonight, and I definitely want to dig into this more, wrap my head around it and the genesis of the whole thing, but I think tonight's a good update, and then, we can kind of look into this deeper and see what we want to do down the road, but I think tonight's just a good update.
I agree.
To your point that conservation is a subject matter dense situation, this would just compound that. This is it's a heavy lift sitting on the Conservation Commission. You've really got to get up to snuff, and this would require different training. This is a horse of a different color from the Wetlands Protection Act and the town bylaw that we currently administer.
Trish, do you have anything to add on it?
I just want to say I love the North River, and, speaking with Attorney Galvin, one important aspect of this commission is to keep the uniformity of the river. And if you're allowing the communities to take that over, then people will set their own rules. So, going up that beautiful river, it could really change the scope of how it looks. So,
Thank you.
I support it.
There are, I believe, 752 properties on the North River, and I think if you polled the owners of most of those properties, they would be dismayed at the thought of this commission being dissolved.
All right, so I know I have it, I think, on the agenda for a vote, but do you guys want to hold off on voting on anything and wait till they possibly have a legislative hearing, or how would you like to move forward on this?
I mean, the pace at which things move up there, I don't think we need to rush. I mean, I might be dead before the hearing is scheduled, so.
That's a possibility, may not get scheduled at all,
Time,
you're absolutely right. You, Trish, what's your thoughts?
I agree. I don't see that a vote is needed, but I do appreciate the information, and I believe I'm the liaison to the
Oh,
conservation.
okay, good, thank
I'll
you.
be speaking
I'm
with
sorry
you.
I haven't had a chance to come in and meet you.
That's okay. I'll be by.
All right, so, I'm
Mr.
gonna,
Chairman, if I could,
yeah, absolutely, Mr. Finn, go ahead.
I would second the fact that there's no action needed tonight. I think we need to see when there's a hearing scheduled. If there's a hearing scheduled, then that's the time to strike.
Yeah, I mean, I
I'd
would
like to
look
know
at,
your opinion.
I mean, I'll bring it back and we can all discuss, but I just look at that. We have some information, we've heard statements from you, Mr. Kearney. I would like to get more information on it, so my look at it is that if this legislative hearing happens, and there's more information to acquire from it, that's what I would like to get, and then we can discuss it again at another meeting after that hearing happens, and then we can go from there in regards to voting whether to support this or not, or
That's
how
right,
it's
yeah.
going to be.
That's good.
Does that sound all right?
Yep.
Okay. I appreciate it. Thank you for your time. Thank you for coming.
Thank you.
Thank you.
All right. Oh, boy. Okay, so continue discussion and vote on Labor Council request for quotation. Peter Martin give details on RFQ in the process, discussion and comments from Select Board, if any. So, Mr. Moran?
Sure.
Oh, you, pal.
Thank you. I'll be very brief. I provided you with the draft RFQ last week. I think it's pretty standard. It delineates what we're looking for in our responses from prospective Labor Council, what we're looking in the qualifications for them, giving you the opportunity to, hopefully look at applications from interested firms, invite one in and do an interview and choose one. So if you have any questions on the RFQs that I've provided earlier, I'm happy to answer them.
All right, so when we're talking about the RFQs, are those the ones that were sent to us by you and Danielle?
Yeah.
Okay, you guys both got electronic copies of those. There's nothing in the binder, but I do recall, and I did have one picked out. So, in my opinion, I thought the Marshfield RFQ was fine. I don't know about the rest of you. See how it yourself.
I agree, yes.
You were happy with the Marshfield RFQ that they've used in the past?
Yes.
Trish?
Yes.
Okay, so I say we just, do you have anything else to add, Peter? We might as well just go and vote on this. You're good with?
Yep, I'm
You good with that?
Yep.
Okay. I move that the select board vote to approve the town administrator sending out the request for quotations in the process for selecting future labor council using the town of Marshfield RFQ. Do I have a second?
Second.
Aye.
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 Thank you, everybody. Okay, discussion and vote on issuing the town council request for proposal. Peter Morgan can get details on the RFP and the process. So is this another thing that we're going to have to come up with in regards to a request for proposal, in regards to us to review?
Yeah, if you decide that this is what you want to do, I will draft something up for you for next meeting.
Okay. All right. I guess that'll be, it's not going to require a vote, right? You draft it up and then we'll vote on it then? Or do you want us to vote on the, you authorize it?
If you decide that this is what you want to do, I'll draft something up for next meeting.
So, do you want to vote from us? Or do you require a vote?
No, if you just give me a consensus that one way or the other, if that's what you want to do, then I will draw something up and then you can vote on it next week.
I mean, I'm going to say yes. I don't know. I mean, I think it's equating to a vote if we give you a consensus
No,
on
okay,
it. So.
I'll just draw it up. You don't have to vote.
Okay.
Okay.
Number 5, no, we just did that. That was town council. Number 6, discussion of vote on request for permission to accept 3 donations, Veterans Services. Acknowledge the Veterans Services. Nope, actually, number 6 here. Let me get this good.
With Mr. Chairman,
Yes.
so did we skip, 5 is the town council action item. I thought we just kind of talked about 4, which is the labor council RFQ.
Yeah, you'll have a longer discussion next week.
Oh, sure, okay. Yep, sorry.
He was,
Yeah, I'm just
Peter,
going to
we were
draw
just
something up.
discussing that, Steve, in regards to the Labor Council, where he's going to put together an RFP or an RFQ, and then he was going to bring it forward to us
You can look at
to
it, then you can
approve.
discuss the merits of it next week.
Okay,
I mean, unless you had something else to add on.
no, I was just going to discuss the merits, but wait until next week.
Okay.
Works, yeah, for
Okay.
sure.
Discussion and vote on request permission to accept 3 donations, Veterans Services. So this is permission to accept donation of $180.15. The Town of Marshfield Veterans Services requests permission to accept donations in the amount of $180.15 from Madison and McKinnon Coldstring and Charlotte Freeman from the lemonade stand. The donation will be used to provide assistance for health and welfare, moral and financial need of our veterans and their dependents. Sincerely, Karen L. Paulette, Director of Veteran Services, Lisa J. Potts, Assistant Director of Veteran Services. I move to grant permission for Veteran Services to accept the following donations: $180.15 from Madison J. McKinnon Coldstring and Charlotte Freeman from the lemonade stand. Do I have a second?
Thank you for the donation, and second.
Aye.
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 Okay, so there's a second one on this. Permission to accept donation of $750. The Town of Marshfield Veteran Services requests permission to accept donations in the amount of $750 from Miss Mary Ann Ferris Donations will be used to provide assistance for health and welfare, moral and/or financial need of our veterans and their dependents. Sincerely, Karen L. Paulette, Director of Veteran Services. Lisa J. Potts, Assistant Director of Veteran Services. Do I have a second to accept $750 from Mary Ann Ferris?
Second.
Aye.
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 Permission to accept $100. The Town of Marshall Veterans Services requests permission to accept donations in the amount of $100 from Mr. and Mrs. Joseph Hanlon. The donations will be used to provide assistance for health and welfare, moral and/or financial need of our veterans and their dependents. Sincerely, Karen L. Paulette, Director of Veteran Services. Lisa J. Potts, Assistant Director of Veteran Services. Do I have a second to accept $100 from Mr. and Mrs. Joseph Hanlon?
Second.
Aye.
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 Thank you, everybody. Oh, I'm going to look for a 5-minute break. Is that, do I have a second on that?
Second.
Aye.
Nay, I'm just kidding. Aye.
Aye.
Start this meeting. Do I have a second?
Second.
Aye.
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 Thank you. Okay, action item number 7, discussion and vote on request for permission to accept donation, Marshfield Cultural Council. Summer content and entertainment series donation. On behalf of the Marshfield Cultural Council, please accept this donation of $50 from Ned Banks. The above donation should be placed in the Marshfield Cultural Council donation and gift account number 222-64800-483000. The donation will be used to support the MCC Summer Concert and Entertainment Series. The MCC looks forward to developing partnerships with local businesses, organizations, and individuals as we continue to expand and upgrade this family-friendly event. Thank you for support for this community event. So, do I have a second to accept the grant for the Marshfield Cultural Council from Ned Banks?
Accept the donation.
Second.
Aye.
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 Thank you, everybody. Let's see here. Number 8, discussion and vote request permission to accept donation, Ventress Memorial Library. Dear members of the Select Board, this is dated May 29, 2025. On behalf of the Ventress Memorial Library, I'm ready to formally request your acceptance of a generous $350 donation from the Governor Winslow School PTO to our Children's Department. We are sincerely grateful for a generous contribution like this, which make it possible for our library to offer resources and programs that might otherwise be out of reach. Thank you for your consideration, Cindy J. Marcoux. I move to grant permission for the Ventress Memorial Library to accept the donation of $350 from the Governor Winslow School PTO. Do I have a second?
Second.
Aye.
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 Number 9, discussion and vote on application for Marshall Fairgrounds Common Victual License Circus Smirkus. So we have named applicant Nate DeBrule, address 1 Circus Road, Greensboro, Vermont 05841. Name of business Circus Smirkus. Date of event July 29th through the 30th. Hours of operation shows at 11 a.m. and 7 p.m. each day. Number of food stands 1. This was signed and dated 4/22/25. That's all the information I have there. Steve, do you have any questions on this, comments?
Did you forget the name of the circus, or is that the name?
That's the name of
Circus Smirkus. I was gonna say, you did this last year.
I did.
I think it's cool that they live at 1 Circus Road.
That's pretty perfect, yeah. I have nothing, sorry. Nothing useful, sorry.
Trish, do you have anything? No. Okay. I move to approve the Marshall Fairgrounds Common Victual License under Mass General Laws, Chapter 140, Section 2, for Nate DeBrule, DBA Circus Smirkus, to have 1 food stand for the Circus Smirkus event on July 29, 2025, and July 30, 2025, contingent on approval of the Board of Health. Do I have a second?
Second.
Aye.
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 Thank you, everybody. Discussion and vote on application for temporary liquor license, Marshfield Agricultural and Horticultural Society. Name of application, Carlton Chandler, Marshfield Agricultural and Horticultural Society. Name of business and organization, Marshfield Agricultural and Horticultural Society. Mailing address, P.O. Box 5, Marshfield, Mass. 02050. Date of event, June 21st, 2025. Hours of event, 3:00 p.m. through 10 p.m. Location of event, Marshfield Fairgrounds, 140 Main Street. Description of event, POVAT Veterans Association Benefit Concert. All alcoholic beverages was checked off. Copy of liquor liability insurance, name of town of Marshfield additionally insured, that was checked off. Copy of tip certification for all servers, that was checked off with managers next to it. This event will be held outdoors, was checked off. If outdoors, please include well-defined scale plan for proposed outdoor consumption area that includes but not limited to, so it just states the fairgrounds in whole. This was signed by Carlton Chandler on 6/4/25. There is a certificate of liability insurance, naming town of Marshfield on it, and certificate of completion, Massachusetts Alcohol Awareness Training for Carlton Chandler. Tip certification completion certifies that Richard Ingham is certified, and no issues with the police, from the police department on this event. And I think that's all I see. I don't see anything from fire, so I don't even know if there was a comment from fire on it, but. I move, Steve, do you have any comments or questions on this?
No, thank you.
Trish, do you have any comments or questions on this? I move to approve a temporary liquor license for all alcoholic beverages for Carlton Chandler of the Marshfield Agricultural and Horticultural Society for the POVAT Veterans Association Benefit Concert event on June 21st, 2025, from 3 p.m. To 10 p.m. at the Marshfield Fairgrounds, 140 Main Street, contingent on liquor liability, name of the town of Marshfield as additionally insured, copy of tip certification for all servers, and approval from the Marshfield Police Department. Do I have a second?
Second.
Aye.
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 Thank you. Discussion and vote on application for common victual license, Pelican Snowballs, 1289 Ocean Street. So we have an applicant here, common victual license application, there, applicant J. Harmony Investment Group LLC, address 125 Church Street, Pembroke, Mass. 02359. Name of business, Pelican Snowballs, business address 1289 Ocean Street, number 1, Marshfield, Mass. 02050. Hours of operation, Monday through Saturday, 12 noon to 9 p.m., Sunday, 12 noon to 6 p.m. Other information, hours may vary due to weather. This was signed and dated by the applicant May 7th, 2025. There's a Commonwealth Department of Industrial Accidents, Office Investigations sheet filled out here. What's that, just workman's comp paperwork?
Yeah.
Peter? And then,
It's proving that he has workers'
Hi,
comp.
sorry to interrupt. This is Jeff Wilson, 26 Noel Road.
yes, Mr.
I
Wilson.
cannot hear you guys. It looks like the town hall is on mute.
You know something, I had my microphone off. Would you like me to repeat what I just said there?
No, that's okay, Eric.
Okay, I apologize for that. Andrew Stewart comment on this, he had no problem with the DBA and sign permit. And I don't see anything here from anybody else, so. I move to approve an annual common victuals license under Mass General Laws, Chapter 140, Section 2 for J. Harmony Investment Group LLC, DBA Pelican Snowballs, located at 1289 Ocean Street, number 1, contingent on approval of the Board of Health and Building Department. Do I have a second?
Second.
Aye.
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 Discussion and vote, request permission to hold 4th Annual Carolina Hill Mountain Bike Classic on August 17, 2025, rain date August 24, 2025. So this is from the Recreation Trails Committee, Annual Carolina Hill Mountain Bike Classic. The Recreation Trails Committee is working with Jeff Wilson to offer our 4th Annual Carolina Hill MTB Classic. The mountain bike race will be held on Sunday, August 17th, between the hours of 8 a.m. and 3 p.m. With the rain date of Sunday, August 24th, we plan to set up at 8 a.m. The actual race will be from 9 a.m. to 2:30 p.m., followed by the end of a race cleanup. We anticipate that the trails will be cleaned up and all materials will be moved no later than 4 p.m. As with last year's event, the race will use existing trails located throughout the Carolina Hills Reservation. The race will be limited to 150 riders between the ages of 12 to an adult. Jeff Wilson, resident trail ambassador and coach of the Wampatuck Warriors Youth Mountain Bike Team, will serve as our race director. Jeff will be assisted by volunteers from the New England Mountain Bike Association, Friends of the Wampatuck State Park Recreational Trails Committee, trail ambassadors, and friends. The bike race will benefit the Recreational Trails Committee in our continued efforts to maintain and improve the growing network of trails. We will have several first aid kits and trained medical staff on hand. Prior to the race, a copy of the race course will be handed to both Marshfield Fire and Police Departments. The map will highlight the race course and identify locations of race volunteers. The volunteers will have cell phones as well as radios for communication throughout the race day. We received positive feedback from last year's participants and look forward to a positive day out in the trails. We are asking the Marshfield Select Board permission and approval to offer this community event. As always, we are available to meet with town officials and departments to review the planned the race and to answer any questions. Thank you for your support for this community event. And that would be from Ned Bangs, and I imagine everybody that's working with them on this. There is a map. IT, do you have the map you could put up there? Ned, do you want to speak on this in any way, or?
Sure.
And there's a map up, so if you can just.
Hi, this is Jeff Wilson. I can speak upon that.
Jeff, on the map?
26 Noel Road. Yeah, so the map is mostly they're all actually pre-existing trails. Some of these other ones were just recently approved. It's approximately 6-mile loop they'll be doing with about 400 feet of climbing. And yeah, it'll be similar to last year. The course is a little different, to throw something different at them. I want to give them the same thing every year. It'll also help break in some of the newer trails.
Unless I'm missing it here, where is it starting from?
It's going to start up on Ames Way beyond the gate, about 1,000 feet beyond the gate. Pretty much the same spot it starts every year. So
Okay.
we get there, we do get there approximately, we set up by like 7 o'clock. The first race goes off at 9:05. The last race is at 12:05, and that's the kids, and they're usually done by about 1 o'clock. And then we just clean up from there, pull down any tape and any stakes, stuff like that.
So is the start and the finish line the same?
Yeah, everything's the same.
Okay. Okay, do you have anything else to add, Jeff?
No, it's a fundraiser race. It's about 150 people. We usually get about a 10 to 15% no-show rate. I'm also involved in the landmine race, which is actually the biggest. That's out of Hingham, Massachusetts. That's the biggest race in New England. That's about 750 people, roughly. And that goes pretty smooth. This is just a small race to raise money to put back into the trails throughout Marshfield. or funds we need for different tools, which we have got some new hedge trimmers, new small little sawzall, little hand snipper stuff, anything like to better the trails and trail systems to maintain.
Is there any prize money on this or any awards?
There's a little bit of money for the pros and the faster, younger kids. I coached the Wampatuck Warriors who are in the New England Youth Cycling. There's approximately 35 teams, and the board voted one team in from New York, so we got 36. And currently, we're in first place with one more race to go, which is over in Hingham at Wampatuck State Park.
Excellent.
This coming Sunday.
Yeah, do you have anything to add?
Just one thing to point out, that it's all contained within the Carolina Hill Reservation. We don't touch any of the streets or roads, things like that, and police and fire have always liked that, because it's one less thing that they have to worry about.
Steve, have any questions?
It's always gone off without a hitch with no issues, so always happy to support it.
Absolutely. Trish?
No, thank you.
Thank you.
Anything else between you and Jeff? Anything that you want to add? Or?
Nah, it's pretty much similar to, previous years. We'll have a lot of the same races, and it's been well received in the past. There's no reason to believe that it won't right now.
All right. So I move to approve the request for the Recreational Trails Committee to hold the 4th Annual Carolina Hill Mountain Bike Classic on August 7th, 2025, with a rain date of August 24th, 2025, contingent on approval of the police and fire departments, and with the event organizer responsible for providing adequate supervision and cleanup. Do I have a second?
Second.
Aye.
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 Thank you so much.
Thank you very much.
Thanks a lot.
Have great
Appreciate
night.
Yeah, you do the same. I wish you guys well on this.
Yeah, take care. Bye.
All right, discussion of vote appointment of Americans with Disabilities Act Committee, Dominique Dyer. So let's see here. Name, Dominique Dyer, 18 Chandler Drive, Marshfield, 02050. Occupation, stay-at-home parent. Checked off ADA Committee. Interest, education, advocacy, inclusion, reading, planning. MED, previous elementary teacher, 2 disabled children, 1 with multiple disabilities, uses AAC mobility devices, co-chair, Neuroscience Family Advisory Council, Math Health Member Advisory Committee. Yeah, Jenna sent this to me like a while back, and for some reason my email doesn't push out the things the way, sometimes I'll get it like a week later, so I apologize for getting this so late, but I'm kind of relying on the email system when it goes through my phone, so, I think that's it, so, any questions or comments, Steve?
Yes, just to kill 2 birds with 1 stone, both Dominique and Julianne will be great fits. They'll be very proactive and very passionate, and I'll just turn to Andrew, who will do it more justice than I will.
Well, actually, hold on. Trish, do you have any questions?
No.
Okay, go ahead, Andrew.
Andrew Stewart, Marshfield Building Commissioner. So the ADA committee, as I understand it, has probably met like twice in the last 4 years. And those meetings addressed very little. Obviously, the ADA accessibility of our playgrounds has been like a major issue. These are 2 of the moms that had brought the enforcement action, and I've been meeting with from the very onset of this issue last summer. They're very passionate, they're very knowledgeable. Julianne, I can speak for Dominique, is actually a very experienced grant writer and wants to bring those skills to the committee and try to help us to get some more money for some of these upgrades that we need to do. And Julianne is also really knowledgeable. Both have children in the system, children with disabilities. Julianne's husband also is a contractor, and they have a lot of interest in trying to help generate volunteer programs through the committee and try to get volunteer efforts to help us with some of these playgrounds with maintenance and this type of stuff, so hopefully cut down on costs. So they've got some really great ideas. They're super passionate. They want the ADA committee to be active and relevant, and I really hope that you would accept their applications. Thank you.
Thank you, Andrew. Yeah, I don't see why not, especially with the playgrounds going around. At least, I know people are looking for a playground committee, but I think the ADA committee, with two active parents like this, could probably do just fine, maybe with the possible playground committee, but I think having two active parents on the ADA, I think could prove well worth going forward, more than a playground committee, in my opinion, but either way, so. Okay, so this is Dominic Dyer. I move to appoint Dominic Dyer to the ADA committee. Do I have a second?
Second.
Aye?
Aye.
Aye.
Okay, let's see here. Discussion and vote on appointment to Americans with Disabilities Act ADA Committee, Julian Kennedy. Name, Julian Kennedy, address 16 Gates Road, Marshfield, Mass. 02050, occupation lawyer. Checked off ADA Committee. My daughter is physically disabled and we have been fighting for fair accessibility for her. I'm also on the board for Impact Athletics, nonprofit for children with disabilities. I've also volunteered for Special Olympics. Nothing else besides Bud acknowledging that he was in favor of both candidates. Steve, do you have any questions or comments in regards to this?
No, thank you.
Trish, do you have any questions or comments on this? Okay, and you summed it up, Andrew, in regards to both of them. So I move to appoint Julian Kennedy to the ADA committee. Do I have a second?
Second.
Aye.
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 Okay, on to the minutes. Do you guys have any questions or comments in regards to the minutes for May 19th and/or June 2nd, as written?
No, thank you.
You good, Trish?
I'm good.
Okay. I move to accept the Select Board open meeting minutes of May 19th, 2025 and June 2nd, 2025 as written. Do I have a second?
Second.
Aye.
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 Motion, I move to adjourn the Select Board meeting of June 9th, 2025 at 9:11. Do I have a second?
Second.
Aye.
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 Thank you, everybody, and have a good night.